Be ready. Start. By notification dated 23/11/1967, the central government, in exercise of its power under Section 17 1A of the Act, granted exemption to the respondent, which is a company registered under the Companies Act, subject to the provisions specified in Schedule 2 annexed to the said notification. The respondent company comes under item number 5 of the notification. Initially, the case of the respondent company is that after the grant of exemption, it framed a scheme and created a trust and appointed a board of trustees from the management of the said trust fund and was thus enjoying exemption under section 17 1A of the Act. It is also common ground that there were defaults on the part of the respondent company in making timely payment of dues towards Provident Fund for the period between October 99 to October 2000 and then again from November 2000 to July 2002. In view of such admitted defaults, proceedings were initiated against the respondent company and by notices dated 10/9/2003 and 11/10/2003 enclosing therewith the detailed statement of delayed remittance of provident fund and allied dues. As contemplated under Section 14B of the Act, respondent was offered an opportunity to represent their case on several dates by the authorities under the Act and their case was listed for hearing, but nobody appeared on their behalf on several dates. Thereafter, on the basis of some representation on their behalf, the matter was heard and the Regional Provident Fund Commissioner to Sikkim and Andaman and Nicobar Islands by a detailed order directed the respondent company to remit an amount of rupees 32,62,153 by way of damages to the respective amounts, failing which it was stated that further action as provided under the Act and the schemes framed thereunder shall be initiated. It is not in dispute that the said order dated 9/6/2004 is an appealable order under the provisions of Section 71 of the Act. However, without filing any appeal, the respondent company filed a writ petition before the learned single judge of the High Court, which ultimately upheld the contention of the respondent company and inter alia came to the finding that under such circumstances, this court holds that the impugned order cannot be sustained in law as the concerned authority demanded damages from the petitioners not only on account of delayed payment of contribution to the trust fund but also on account of delayed payment of the contribution to the pension fund and insurance fund. The learned single judge, while allowing the writ petition, proceeded on the basis that the expression so far as may be in section 17 1A of the Act will have to be given its proper meaning. If such meaning is given, then the provision in sections 6, 7A, 8 and 14B of the Act cannot be applied in their entirety. The learned single judge held that the expression so far as may be cannot be treated as a surplusage. The learned single judge further held that the said expression so far as may be used in section 17 1A of the said act is for the purpose of restraining the application of provisions in sections 6, 7A, 8 and 14b to the exempted establishment. The learned judge also held that the damages which are recoverable under section 14b of the said act could not go to the hand of the individual affected employee. In case of delayed payment, loss of the individual affected employee is compensated by payment of interest under section 7q of the said act. Since the damages which are recovered are not paid for compensating the losses of the individual employee, the expression so far as may be used in section 17(1)(a) of the said act does not require liberal interpretation. The said finding was given by learned single judge in the context of the argument made on behalf of the appellant that the act, being social welfare legislation, needs to be liberally construed. Thereafter, an appeal was taken to the division bench of the High Court by the appellant. The appellate court also came to the conclusion that section 6, 7a, 8 and 14b of the act would not be attracted to the defaulting exempted establishment. In view of the fact that section 17(1)(a) makes it clear that those sections would be applicable so far as may be, the appellate court accepted the reasoning given by the writ court and affirmed the judgment. Thank you.